Can I welcome you all to the third in a series of talks by Garden Court on the rights of protest. And today the topic is Justification Defences, Direct Action and Freedom of Expression. My name's Henry Blaxland. We have three speakers today, Owen Greenhall, Shahida Begum and Shina Animashon. And Owen's going to start. And just by way of a brief introduction to the talk, which I am chairing, this talk is about the legal defences in the context of civil disobedience. And this is a hot topic at the moment, as you will all appreciate. There's a long history of what I'm going to call political defences in cases involving people who have been involved in protest of one sort or another. I mean, going right back to the 1970s and the 1980s, the St. Paul's riot, the notion of community self-defence, and in particular in the context of the statutory defences of reasonable excuse in the context of criminal damage and lawful excuse in the context of obstruction of the highway. I mean, no doubt when we all saw the images of the slaver statue in Bristol being thrown into the water, we wondered what defence those people who were eventually arrested might have, and no doubt the defence of reasonable excuse sprung to mind. Today we're going to be focusing specifically, as the title of the meeting suggests, on the specific defences of necessity, prevention of crime and protecting property, and looking at their limitations and the scope for development. And the webinar will also examine how the courts should give proper weight to the right to protest within a criminal trial, including looking at the development of the domestic case law from the case of James and the DPP through to the case of Ziegler and onwards, as well as relevant European Court of Human Rights authorities. Before I introduced our first speaker, who's Owen, I have just a few technical matters which I need to draw to your attention, which I think have come up probably in the chat section, but just in case you haven't got that, just so that you all know, you've all been placed on mute, so please post your questions in the chat window so I can collate the questions and pose the questions to the speakers at the appropriate point. The presentation slides will be circulated to the registered participants. And this webinar is being recorded. And what that means is that the audio and video of the presenters and anyone who speaks, if they are unmuted, will be recorded. And this webinar, so you know, may be shared on our marketing channels, including our website and social media, though no other audio, video, or personal data will be recorded or shared. Right, without more ado, that's the formal blurb over. Can I please introduce Owen? Owen has as many of you will know, a mixed civil and criminal practice that has extensive experience representing protesters in criminal trials, civil actions against the police, and injunctions and public law proceedings. He's appeared in the case of the DPP and Stratford magistrates, and indeed in the case of Ziegler, where he appeared as my junior, but did all the heavy lifting. He's a co-author of the Protest Handbook, and there's a new edition coming out later this year, I must mention. And his talk is covering the related defences of necessity, prevention of crime, and protection of property as they arise in the protest context. So, Owen, over to you.
Thank you very much, Henry. I hope everyone can hear me. I'm sure someone will indicate if they can't. I'm going to start sharing a screen with some slides. I'll do that now. I hope people can see the first slide. There also should have been a brief handout circulated by email, which has all the gory details of the various authorities that I'll be referring to. So hopefully I won't have to go through all the details in my talk, and you can see all of that there. The the common element of the talk that I'm talking about and the defences that I'm going to talk about are really their offences where the basic fact of them is that what the defendant says they did is justified. The defendant is saying that they were right to do what they did. Then it's not some sort of excuse or technicality or other defence like that. It's saying, no, this is what I had to do in those circumstances because I was acting for the greater good. And the origin of the defence of necessity, at least in sort of very recent times, is Stephen, a Digest of Criminal Law. It goes back to 1877, and that states an act which would otherwise be a crime can be excused if the person accused can show it was done only in order to avoid consequences which could not otherwise be avoided, and which, if they had been followed, would have inflicted upon him or upon others to whom he was bound to protect inevitable and irreparable evil, and that no more was done than was reasonably necessary for that purpose, and that the evil inflicted by it was not disproportionate to the evil avoided. So that, in general terms, is a very broad statement of principle. It's an incredibly broad notion of a defence. It has the essential elements that what is done is only done to avoid consequences which could not otherwise be avoided. There's no other evasive action available, and you don't do more than is reasonably necessary to stop the harm that you're trying to stop. And it's interesting to look at the examples that are cited in that book as to where the defence might arise. In particularly, the first one, a governor of Madras acts towards his council in an arbitrary and illegal manner. The council deposes him and puts him under arrest and assumes the powers of government themselves. This is not an offence if the acts done by the council were the only means by which irreparable mischief to the establishment at Madras could be avoided. So moving on a swift 100 years or so, we get to the more modern formulation of the defence in the case of Martin, and that states that English law does, in extreme circumstances, recognise a defence of necessity. It arises usually as duress by threats, but as Martin says, it can arise from other objective dangers. It can be commonly called the duress of circumstances. So it doesn't have to be an individual who says, you must do this or else. It can be the surrounding circumstances that just means a person has no other alternative. But it does require a reasonable belief in a threat of death or serious injury, and it's only available if you act reasonably and proportionately in response to that threat. And the formulation which the court came to in Martin was assuming the defence is open to the accused. The issue should be left to the jury to decide, and they should be asked primarily two questions. First, was the accused, or may he have been impelled to act as he did, because as a result of what he reasonably believed the situation to be, he had good cause to fear that otherwise death or serious physical injury would result. And second, if so, may a person of reasonable firmness, sharing the characteristics of the accused, have responded to the situation as the accused acted? And if the answer to both of those is yes, or may have been yes, in the context reflecting the burden of proof in a criminal trial, then the defendant is entitled to be acquitted. And that formulation contains the basic elements of this defence. It's in a somewhat compressed form. The case law has examined various parts of the defence, and there's been quite a lot of conflicting authorities on it. But the authority that I want to deal with first is the case of Abdul Hussain. And this is a picture of Stansted Airport. Stansted Airport seems to play a significant role in the defence of necessity. There are a large number of cases which somehow seem to be related to this particular location one way or another. And the facts of Abdul Hussain were that the defendants were in the Yemen. They feared deportation to Iraq under Saddam Hussein. And in order to avoid that deportation, they hijacked a plane using plastic knives and an imitation hand grenade. They forced the plane to take off and fly first. I think it landed in Cyprus, where it refueled. And then it continued on to Stansted Airport, where it landed. And there was a standoff on the tarmac at the runway at Stansted Airport for some 48 hours. Now, clearly, the threat of deportation to Iraq, and it was only once they had been taken to Iraq that the actual physical risk of harm would have materialized. That is clearly quite distant from the tarmac at Stansted Airport. And they were charged with hijacking offences and convicted, and they appealed to the Court of Appeal. And the Court of Appeal quashed the convictions. And in doing so, the Court of Appeal examined the defence of necessity and set out a number of the basic elements to it. And I haven't listed everything in that case. There is an enumeration of about 11 points. I've reduced that to 6 for the purposes of this talk. And the first thing to note is that the scope of the defence remains unclear. I think that is true even today. They cite the case of Shaler. The distinction between duress of circumstance and necessity has largely been blurred by the court, and any attempt to define the limits of the defence is fraught with difficulty. And then when that case got to the House of Lords, Lord Bingham said that this was vexed and uncertain territory. It seems one of the reasons for that is that the defences of necessity, defences of duress, but commonly duress by threats, also duress of circumstances, are all slightly different variations with their own slightly different factual scenarios. And it is very rare that the court deals with a defence of necessity in its purest form. It's always dealing with some subcategory of the defence, and therefore drawing general principles across the cases remains difficult. It is, however, clear that defence of necessity is a defence to pretty much all crime except for murder. It's also not a defence to attempted murder, some forms of treason. But other than that, unless there's a very clear statutory provision excluding a defence, it will arise. It's important to note the case of Quayle, where necessity was raised as a defence to drug offences on the basis that users were taking cannabis to relieve symptoms of pain, essentially. And the court there took as one factor as to why necessity didn't arise on those facts, that the statutory scheme of drug control would have been undermined if relief of something like pain, a very subjective matter, would have been allowed as a basis to a defence. But that decision to restrict the scope of necessity hasn't spread to other areas. The more recent case of Lane and Letts was a case which Henry Blaxland was involved in. It concerned whether necessity could be a defence to a charge of funding terrorism. And a similar argument was put forward by the Crown that the statutory scheme as a whole was such as to preclude a general defence of necessity applying. And that was, the court ruled against the Crown on that point, and necessity was left to the jury on a number of the counts on that case, and the jury in fact acquitted on those ones. Interestingly, on the question whether necessity could be a defence to murder, the conjoined twins case in fact suggested that necessity might be a defence to murder in those cases, and it is difficult to see if necessity did arise, how it, on those facts, but how it wouldn't apply. That was the case where doctors had to perform an operation on two conjoined twins. Performing the operation would have saved the life of one twin, but would have inevitably meant that the other weaker twin would have died. So That's the types of offences to which the defence can apply. It is clear that there has to be a risk of death or serious injury in order to have any basis to run this defence. A risk of suicide is sufficient. The case of Martin itself, the defendant there acted in order to stop his wife from committing suicide. He effectively drove his son to school or to a job whilst he was disqualified in order to avoid a situation in which he feared his wife might commit suicide if the son lost his job. Court said it's a matter for the jury to decide. It doesn't preclude the defence. But as indicated, simply a risk of pain is not enough. Also, damage to property doesn't fall squarely within defence of necessity. There, you'd need to look towards the statutory defences of protection of property and prevention of crime, which I'll come on to later. There does need to be a risk to the defendant or those for whom he has responsibility. In the case of Shayla sets this out. It's also in the case of Abdul Hussain. But it's important not to take this too far. You don't have to be able to name the particular individual whom the defendant is trying to save. You don't really have to be able to identify them. You just have to be able to describe them, possibly by reference to the acts taken. So, for example, if a person took action to stop a bomb going off in a hotel, well, the people for whom he was seeking who he had responsibility was the people who faced the danger from the bomb. And his knowledge that there was a bomb about to go off is sufficient to give him the responsibility to do something to stop it. But if you can't identify, even by description, the people with whom you're trying to prevent harm, then the court has indicated it can be difficult to establish a basis on which you can be said to have responsibility for them. In direct action protest cases, the case of the Lord Advocate's reference is one that's often cited. And that basically says that having any sort of prior connection between the people, the defendant, and the people that he's trying to save has nothing to commend it. And it cites the example of an industrial plant. So many industrial plants have the potential for mass destruction over a very wide area. Now, if someone, knowing that there was a risk, for example, of an explosion there, and they did something to stop the explosion happening, something which would otherwise be criminal, there's no compelling reason to exclude the defence of necessity simply on the basis that people at risk were remote from the plant, even remote on a sort of international scale, as long as they are within the area of reasonably foreseeable risk. The next element of the defence, which the courts have identified, is that the risk or threat of harm must be such as to overbear the defendant's will. In the case of Hudson and Taylor, it was stated it's essential for the defence of duress that the threat should be effective at the moment when the crime is committed. The threat must be a present threat in the sense that it's effective to neutralise the will of the accused at the time. It's basically saying that the person had no choice whatsoever. The facts of that case are illustrative. They're two teenage girls who'd given false evidence in a court, in a trial, due to threats that had been made to them. And they were then, when that was discovered, subsequently faced proceedings for perjury. But it's important to remember that's a duress by threats case, and arguably the cases of pure necessity are different. If you look at the conjoined twins case, the court said, well, in cases of pure necessity, the actor's mind is not irresistibly overborne by external pressures. It's really the decision of making a rational choice between two evils. The doctors there were not acting under any sort of compulsion. They were simply doing what they saw as being the rational way forward to avoid the greater harm. The risk has to be imminent. That's another factor which the courts have relied on. And in Abdul Hussein itself, it says, imminent peril of death or serious injury to the defendant or those to whom he has a responsibility is an essential element of both types of duress. So that's both duress by threat and duress of circumstances. But of course, it's important to remember the facts of that case, because what Abdul Hussein went on to say is the execution of the threat or risk doesn't have to be immediately in prospect. And if you think about it, going back to Stansted Airport for a bit, we have there a long causal chain from the plane when it is on the tarmac at Stansted Airport to the harm which was sought to be prevented. The harm was the risk of deportation to Saddam Hussein's Iraq. Well, once the plane had landed in Stansted Airport and been there for 48 hours, the hijacking was ongoing, it was still continuing. And yet the Court of Appeal said, nonetheless, that is still a sufficient threat, even for the defendants where they were there in the UK, that they could rely on defensive duress, or at least it was something that the jury would need to consider. And on this point, there's another hijacking case of Safi, which again ended up at Stansted Airport, as everything seems to do in these cases. And in that case, the causal chain was even further. The plane had been hijacked, and I think it was from Afghanistan, and then went initially to Moscow, and then from Moscow possibly to Germany, and then to Stansted. There was several different stops on the way, but still the court said the causal chain remained unbroken. Defensive duress could be considered. And we get the nice quote from the case of Abdul Hussein, which is that if Anne Frank had stolen a car to escape from Amsterdam and been charged with theft, the tenets of English law would not have denied her a defence of duressive circumstances on the basis that she should have waited for the Gestapo's knock on the door. The point made very effectively is you don't have to wait for the absolute last minute. You can take action in advance of that. But this point is one that's been subject to attack in more recent times. And Tom Bingham, in the case of Hassan, explicitly criticised the weakening of the requirement of imminence and immediacy. The court of appeal in Abdul Hussein, where that quote, the Anne Frank quote, comes from, considered that it was bound by previous decisions, in particularly the decision in Hudson and Taylor, the teenage girls perjury case. Bingham said, insofar as they were relying on that case, they were wrong to do so. Hudson, in his view, was an indulgent decision, and it weakened unduly the requirement of imminence. And it has to be, the threat really does have to be reasonably believed to be imminent and immediate if it is to support a plea of duress. But you have to remember, Hassan and Hudson and Taylor are cases of duress by threat. And that is a subspecies of necessity as a general defense. And it may well be that in cases of duress by threats, the need for a connection and imminence is much greater than with other forms of necessity. If you look at the pure necessity cases, the West Berkshire Health Authority case, the court said emergency is not the criteria or even a prerequisite. It's just a frequent origin of a defense of necessity, but the principle is necessity, not emergency. And even going back to the case of Hassan, Bingham himself said, well, it should be made clear to juries that the retribution threatened must follow immediately or almost immediately. So it's a matter for the jury to take account of that. This is not a factor in which the court is entitled to withdraw a defence of necessity. So that's what I want to say in terms of defence of necessity. I want to move on now briefly just to look at defences of prevention of crime. As I'm sure is well known to people, Section 3 of the Criminal Law Act 1967 sets out a statutory defence of prevention of crime. That statutory defence essentially codifies what was previously a common law defence. And it gives a basis for the use of effectively reasonable force in preventing crime. And it has two limbs. It has a subjective element. Defendant must honestly believe he was acting to prevent a crime in using force, and in the circumstances the defendant saw them to be the force used was reasonable. Now, it only applies to the prevention of a domestic crime. In the case of the Crown and Jones, there's a number of conjoined appeals in protest cases where people were relying on the illegality of the war in Iraq under international law as a basis of defending their actions. There has to be some sort of nexus between the act of the defendant and the crime prevented. That's a point that was stated obiter in the Jones case, but very much made explicit in the Stratford magistrates case. And again, a requirement of there has to be an imminent or immediate crime prevented. The statutory defence only applies to the use of force. That can be read straight off the statute itself. It says a person may use force. So the question arises, well, what is force? Force doesn't have to be directed against a person. So force against property counts. Pushing a door shut would count as force. And even in cases where there isn't force used, actions which are done to stop crime, such as sitting in a road where you're not actually pushing against anything, you're simply there, you're simply using your presence, those actions can still fall within a general defence, the prevention of crime, because the statute only codified what was the pre-existing common law defence. That common law defence still exists. It hasn't been taken away, and particularly where it applies for actions that don't involve force. So if you're using force, you fall back on the statutory defence. If you're not using force, you've still got common law. That argument was approved in the Stratford magistrates case. Something short of the application of force can give rise to a defence. It's been approved by the High Court in the Sheffield and Brooke case in 2018. That was in the context of contempt of court proceedings, but again, explicit approval of the approach taken in the Stratford Magistrates Court. There is a related point about actions which aren't taken to stop criminal offences, but actions which are taken to do things such as prevent a breach of the peace. The power to prevent a breach of the peace is something which can be used by the police. It's a power which, in fact, applies to everyone. Every citizen has the power to prevent a breach of the peace. And that can justify action which might otherwise be criminal. In circumstances when you're not preventing a crime, but you are preventing unrest of some kind. And it's interesting to consider the case of Humphreys and Connor, which is an old case from 1864. That case, a person was walking down a street. It's an Irish case, and was wearing an orange lily. That was a symbol which was seen as so offensive, such as to give rise to a level of agitation amongst the general public. And the police officer walked up to this man, took the orange lily from his lapel and plucked it out. And the court held that the police officer was entitled to do so as a means to prevent a breach of the peace. Well, that principle that action can be taken to remove symbols which are so offensive that they are causing unrest in the population is a principle which you might look to see if it applies in more modern contexts. In particular, if we have symbols that are associated with the slave trade, which are providing such upset to the immediate population that are in front of them, that something has to be done to stop it. Well, there might be a way of defending your actions as a means of preventing a breach of the peace. And talking of damage to property and things like that, I want to move now on briefly to the Criminal Law Act 1971, statutory defence to defence of criminal damage. That states that basically under statute, a person will have a defence specifically to a charge of criminal damage if they take action in order to protect property or to protect a property right. And it has a very subjective formulation of the defence. Effectively, the defence arises if subjectively the defendant believes the property was in immediate need of protection and the defendant believed that the means adopted were or would be reasonable in the circumstances. So it's the defendant's own assessment of the reasonableness of the actions which matters. That's a distinction from necessity and the prevention of crime defences, which have a much more objective test. There's no requirement that the damage that you are preventing has to be unlawful damage. So if there's a threat from a wildfire or something like that, and you tear down a building in order to create a fire break, that would fall within the defence. There's no requirement that the defendant is solely motivated to prevent damage to property. The defendant can have other motivations as well, as long as preventing damage to property is one of his motivations. The case of Chamberlain and Linden establishes that point. And it's quite clear the courts have noted that this defence gives a very considerable latitude to those who want to take direct action. And as a result of that, the courts have sought to limit the defence. And the case of Hunt looked at trying to impose some sort of objective restriction on the defence. And the way the court approached it was to say, well, the question whether a particular act of destruction or damage was done or made in order to protect property was, on the true construction of the statute, an objective test. So whether the defendant is actually acting in order to protect property, that's where the objectivity supposedly comes in. It is difficult to read this into the statute in any sort of natural way. The consequences of it are that actions such as cutting a wire in the perimeter fence of an airbase as a means to draw attention to the actions of the armed forces and thereby stop those actions, that was held to simply be too remote from the harm that was prevented. The harm is the harm caused by the armed forces overseas. The action is cutting a wire. And the court said that the judge would be entitled to withdraw a defence in those circumstances. Similarly, writing a message on the wall, on a pillar in the Palace of Westminster, was again held to not have the required degree of connection between the harm prevented. And this trend of looking particularly at protest cases and seeking to shut down the defence's run is something which the courts have on occasion been very keen to do. And the most clear example of that is in the case of the Crown and Jones in the House of Lords, the 2000 decision, and it's the speech of Lord Hoffman. And he, in his judgment, has a fairly remarkable section on the limits of self-help, which starts with looking at who should assess the reasonableness of a defendant's actions and how should they go about doing it. And what Hoffman says is that the crucial question is whether one judges the reasonableness of the defendant's actions as if he was a sheriff in a western, the only man in town, or whether he should be judged in its actual social setting in a democratic society with its own appointed agents for the enforcement of the law. And he goes on to say, well, in a case where the defence requires that a defendant should in all circumstances have been reasonable, his acts must be considered in the context of a functioning state in which legal disputes can be peacefully submitted to the courts, and disputes over what should be law or government policy can be submitted to the democratic process. And in such circumstances, the apprehension, however honest or reasonable, of acts which are thought to be unlawful or contrary to the public interest cannot justify the commission of criminal acts, and the issue of justification should be withdrawn from the jury. The case there was dealing specifically with the defence of prevention of crime, but these comments would appear to have, at least on one reading, a wider application. They appear to be saying, whenever you have a justification defence which requires a jury to make an assessment of the reasonableness of your actions, that has to be filtered through the prism of viewing these things as taking place within a democratic society, and in those circumstances, effectively not using the usual democratic processes to bring about change cannot be justified. And it's a very difficult passage for those who wish to defend people who are relying on acts of direct action. It's very questionable in its political and philosophical underpinnings, because there are all sorts of flaws with the current democratic processes, and it's simply not possible to bring about change that way. And the courts are also replete with examples where the right to protest is upheld as somehow as absolutely fundamental in democratic society and must be cherished. It's important, I think, to compare the comments of Lord Hoffman with earlier comments in the case of Wang made by Lord Bingham. And that Wang concerned the role of a jury and when a defence can be removed from the jury. And what Bingham said, approving words of Sir Patrick Devlin, he said that the last word should rest with the jury who remains an assurance that the criminal law will conform to the ordinary man's idea of what is fair and just. If it does not, the jury will not be party to its enforcement. The executive knows that in dealing with the liberty of the subject, it must not do anything which would seriously disturb the conscience of the average member of Parliament or of the average juryman. I know of no other real checks that exist today upon the power of the executive. That is a very powerful statement about the role that juries play in assessing the reasonableness of a defendant's actions. And when it comes to actions and cases of direct action protest, it is really ultimately for the jury to decide whether actions are reasonable. To put it very simply, if a prosecution can't make a jury sure that what a defendant did was unreasonable, then why should they have criminal liability imposed on them? That's what I wanted to say. I'm going to stop there and I'm going to hand over to the other speakers.
Right. Am I unmuted now? Sorry, I've got my mute button on. Right. Yes, sorry. Thank you very much indeed, Owen. I think the battleground has proved to be frequently in these cases to resist attempts by the prosecution to prevent the defence being put to the jury at all. Certainly that's what has been found, I think, in the Extinction Rebellion cases. And so it's very helpful to be reminded about the line of authorities which requires effectively there to be exceptional circumstances for defence to be withdrawn from the jury. Can I then move on, please, to our next speaker, who I'm going to introduce. This is Shahida Begum. She's a criminal defence barrister. She has a significant appellate experience. She's represented numerous anti-fracking and other environmental protesters at trial, and she was junior counsel in the High Court case of James and the DPP. And her talk's going to cover the means by which the right to freedom of expression and assembly is given weight within the context of a criminal trial. Can I just say, before I hand over to Shahida, that if you want to ask questions, we hope there'll be time. We've got 35 minutes left, which is running it a bit tight, but there's, if you've got questions, could you please use the chat facility, with which I'm sure you're all now well familiar. Thank you very much. Over to you, Shahida.
Thank you, Henry. So I've prepared some slides also, which have quite a lot of detail, and they're going to be circulated. So I'm not going to go through each single slide in detail, just the general principles. So if I just get those slides ready. Right. So as you can see, I'll be focusing on, in particular, Article 10 and 11 and criminal proceedings, with a focus on the case of James, which I was involved in, and the case of Ziegler, which Henry was involved in. The defences that Owen has been referring to would be available to a numerous amount of defendants. My particular focus for this talk will be defences and other considerations specific to protesters exercising their Article 10 and 11 rights. So how can the courts give effect to Articles 10 and 11? One way is through considering the proportionality of the prosecution. Secondly, interpreting the elements of the offence or a statutory defence compatibly with convention rights or the Human Rights Act. And then also justification defences, which obviously Owen has just covered. So dealing with first the proportionality of the prosecution, we start with the case of Dehal. And Mr. Dehal had various complaints about a particular Gurdwara and the management of that Gurdwara, and was protesting about it. And he was charged with an offence contrary to Section 4A, which is causing harassment, alarm and distress with intent. Now, the hearing had to be rushed. It's a bit unclear what the reasons were, but I believe there was some other civil actions maybe in the background. But in giving judgment, then Mr. Justice Moses in 2005 stated that before there was any consideration of guilt or otherwise, because Mr. Dehal was exercising his freedom of expression, the prosecution would have to prove that their response, bringing a prosecution, was proportionate to the conduct, particularly where there hadn't been any public disorder or violence. So that was a high point in terms of considering the proportionality of the prosecution and the approach by the court. This was followed in the case of Munim Abdul, and that was a protest against British soldiers who'd been returning from Iraq and Iran. It was at a homecoming parade, and the protesters were voicing their opinions about the conduct of the British soldiers overseas. And that case, although the question was framed slightly differently for the High Court, they also did agree that the prosecution have to show that there's a proportionate response in bringing the prosecution. And the panel of that court was Lord Justice Gross and Mr. Justice Davis. However, 8 years after Dehal, by then Lord Justice Moses had a change of heart. He realised that he hadn't in fact provided any framework for some of the comments that he had made. And also it would be tantamount to requiring the prosecution to produce an additional element of an offence whenever Article 10 and 11 rights were engaged. He tried to express his reservations by limiting what he had said in Dehal to the facts of the offence in that case, and simply that it was a restatement of principles that have been well established, that freedom only to speak inoffensively would be no right at all. And also, he went on to that particular case related to aggravated trespass and really was decided on particular issues in relation to that offence. These were obiter remarks. However, he did say that once the prosecution have established all the elements of aggravated trespass, they do not need to go on to prove that the prosecution was proportionate. So following that, again, by then, it's Lord Justice Davis, 5 years on from Munim Abdul, also had a change of heart. Having heard full argument in Munim Abdul and following the reasoning in Dehal, he stated, and it's in the lower paragraph, that it seemed to him that in reality, Lord Justice Moses was in fact recanting from the legal approach he'd previously taken in Dehal. Although he was trying to say it's limited to the facts of that case, in truth, he was recanting. And in the same vein, Lord Justice Davis was also going to recant on his position. So that the courts would very much want to be the end of any sort of challenge to the proportionality of prosecutions, particularly in the magistrates' court. However, it is still worth bearing in mind the CPS Code of conduct in relation to public protests, because there are factors that militate in the prosecution pursuing prosecutions, but also factors that militate against. So there may always be scope for making representations, an abuse of process argument, or judicial review. Obviously, abuse of process and judicial review are very difficult remedies, whether it's the Magistrates' Court or the Crown Court. But it's always worth bearing in mind, certainly the case of James left it open for abuse of process. If there was to be any challenge to the proportionality of the prosecution, it's not an element of the offence the prosecution have to prove, rather the defence would have to satisfy the court that it would be an abuse of process. And there may be cases where the prosecution make a mistake or are extreme or there are unique facts where this can be pursued. The other thing to bear in mind, which sometimes gets overlooked perhaps in the criminal process, is that where there is a large-scale protest, or there's a protest that the authorities are anticipating, they may devise their own briefing material or their own policy documents that are separate to what's in the CPS Code. So policy documents about when the threshold of arrest might be met. For instance, they might have a staged process where they offer somebody to move themselves from a location 3 times. They may give them 3 warnings, and then the next time they will arrest them, which may or may not be a proportionate response. But what should be borne in mind is that really, in those cases, there should be disclosure of those policy documents. And they might not always refer to them as policy documents, but in essence, that may be what they are. And if that is the case, an individual is entitled to access to that document so that they can make representations on their behalf to ensure that the policy is being followed accurately. And the authority for that is actually an immigration case of Lumber. So I've put the reference there, if that's something that arises in any cases that you have, which I think is quite an interesting issue, because more often than not, they do have some sort of separate documents and do try to resist disclosure. So then where does it leave the courts? If the courts have decided the proportionality of the prosecution no longer has to be proved, how else can the courts give effect to Article 10 and 11 rights? And that brings us on to the case of James, which is the case that I was involved in with Tim Owen, Queen's Counsel from Matrix. And essentially, Miss James and some others were protesting outside the RCJ. From memory, it was about corruption in the judiciary, and the nature of the protest was they had some material on the pavement, but also they would cross and recross the zebra crossing. So obviously bringing the Strand to a standstill for periods of time. So a Section 14 order was made by a police officer that they can continue to protest, but it can't be on the crossing, and also they can't take up the whole of the pavement. And that was made until 5 p.m. on that day. So they complied until 5 p.m. on that day, and at 1 minute past 5, they decided to start crossing the zebra crossing again. So the officer made a second order, and there was a bit of a factual issue about whether that had been heard by all of the protesters. But in any event, the officers then started making arrests. Now, it was acknowledged in the case of James that even though the prosecution no longer have to prove the proportionality of the response of bringing the prosecution, that doesn't mean that Article 10 and 11 rights are irrelevant. They have a role to play in the trial process. And what they identified from the previous case law is different ways in how that has been given effect in the past. So firstly, they considered, this is at paragraph 34, that there are some offences which have a statutory defence of reasonableness, particularly pursuant to the Public Order Act. So where there is the statutory defence of reasonableness, it's quite easy to balance in Article 10 and 11 considerations as against what may have otherwise been criminal conduct. And so, one example is Section 5 of the Public Order Act, where you've got the offence, but then you've also got a statutory defence as well. So that's all very straightforward. They then said that there are some offences where the offence creating provision has already taken into account any assessment of proportionality, and the conduct of the accused would go beyond what would be considered reasonable conduct. So there does not need to be any further assessment of convention rights. And the example given is the offence of aggravated trespass. So that was the offence in the case of Bauer, which involved some protesters in, I believe, Fortnum and Masons, and they were protesting against tax avoidance. And they said this is one of those offences where once the elements of the offence have been proved, the criminal conduct is such that there is then no need to go on to balance out the Article 10 and 11 rights. Now, in my view, I cannot see, having represented defendants who've been charged with aggravated trespass, and it's simply been them sitting in trees that they didn't want to be cut down or things of that nature. And the maximum sentence for this offence is 3 months in custody or a fine or both. In my view, I cannot see why the criminal conduct in this particular offence would necessarily be so egregious that you shouldn't have to consider any Article 10 and 11 rights. There are some offences where obviously, those considerations might not apply. For instance, any offences against the person and of that nature. But in my view, there should be further consideration. And in fact, there probably is scope for challenge in relation to other offences which aren't obviously susceptible to building in an Article 10 and 11 protection. So then they went on to consider that you can also take into account Article 10 and 11 rights where there's an element of the offence which would allow you to do so. And the example given was obstruction of the highway, because that requires the prosecution to prove that any obstruction was without lawful authority or excuse. And that has been interpreted even pre the Human Rights Act for several years as an assessment of what's reasonable in all the circumstances. So this is the actual section creating the offence. As you'll see, that's where it's inbuilt. So again, an easier way to factor in Article 10 and 11 rights into the assessment of a defendant's conduct. The difficulty in James was that breach of a Section 14 order does not have a statutory defence of reasonableness, and neither is there any obvious element of the offence which would allow you to consider the reasonableness of a defendant's actions. But because the court did want to give effect to Articles 10 and 11, they latched onto, as it were, the words that I've underlined reasonably here, and as appear to him to be necessary. So the provisions allow an officer who is at the scene to assess the situation and decide if the direction should be made, and also to impose conditions that are a reasonable response to whatever disorder that the officer believes to be necessary in that situation. And the court held that a defendant will only be can be found guilty if it's a lawful direction and if it's a lawful condition that has been imposed. And the way to building Article 10 and 11 considerations is to look at whether the officer's reasonable belief in imposing a direction was proportionate, and also consider whether the conditions that were imposed were proportionate and necessary. If they were, then that is a legitimate interference with an Article 10 and 11 right. If they weren't, then it's an unlawful condition and the person would be entitled to be acquitted. So they took a Section 3 approach to the legislation and tried to read it compatibly with convention rights. So that's just a section from the judgment that explains what, reflects what I have just explained. So then we get on to the case of Ziegler. And this is actually Owen's case and Henry's case, so I hope I do it justice. But if there are any questions, it will probably be better directed at them. In the case of Ziegler, there were several protesters, but there were two groups within that were being dealt with by the High Court in last year. So there was the first group, I believe, who'd locked on to each other and were lying down in the road. And then there was another group of protesters who'd suspended themselves from a bridge. So normal traffic could pass, but not lorries. And the reason why they were protesting is because there was an arms fair that was going on nearby. There were other routes to the arms fair. So it wasn't the case that anybody who wanted to go to the arms fair wouldn't be able to. Also, they were, I believe, in situ for less than 2 hours. So the police did have a 5-stage process of removal, and eventually they were removed. And there had been no complaints, I believe, from members of the public about the traffic and so on. Now, in Ziegler, the court is at pains to stress that they're not doing anything new, and that the line of authorities pre the Human Rights Act in relation to obstruction of the highway would be consistent with whatever they were saying in their judgment. However, there is a pointed paragraph where they say that the Human Rights Act 1998 was a significant shift, and that they were providing the guidance pursuant to that because it had never been properly considered by the courts before. And they in future cases, they need to bear in mind their judgment when considering any pre-human rights case law. And the pre-human rights case law, there's several authorities, but I think it's encapsulated best by the case of Nagy and Weston, and that's from 1965. But essentially, it's a very fact-specific question, and its focus is on the defendant and whether their actions were reasonable. And you'd look at the circumstances, the length of time, any complaints, the purpose, and so on. In Ziegler, however, the court's approach was that the Human Rights Act had created a significant constitutional shift. So what needs to be adopted is the usual proportionality inquiry. And the questions are set out here, as you can see. Was the defendant exercising his or her rights? If so, is there an interference by a public authority with that right? Is it prescribed by law? Is it in pursuant to a legitimate aim? Is it necessary? And in relation to the last question, there's a further set of sub-questions, which I'm sure you're all familiar with. Again, they reiterate that in order for a fair balance to be struck, it will inherently be a fact-specific inquiry. So that doesn't sound very different to what has gone before in terms of comparing it to Nagy and Weston. However, once you get to paragraph 92 of the judgment, the focus then seems to be not on whether the defendant acted reasonably, but whether the interference with the rights of Article 10 and 11 were proportionate. So rather than the protesters and their behaviour, more often than not, did what the police officers did, was it proportionate and justified? And you can see how approaching it from that different angle may, in some cases, make a difference. And in fact, in Ziegler, it did, because Owen and others were successful at the Magistrates' Court in front of District Judge Hamilton. However, the prosecution appealed by way of restated, and the High Court held that, in fact, this the interference with the protesters' rights was proportionate. And it's because that carriageway had been completely blocked. It was for significant periods of time. It was of little relevance that there'd been any other complaints. And quite surprisingly also, the way that they approached their review function as an appellate court wasn't the usual test of whether the lower court tribunal could not have come to that conclusion based on the evidence. Their approach was applying the test of proportionality. They thought, in their view, the district judge had been wrong. And that was following some case law from, I believe, the family and extradition cases. There are, however, some positives in the case of Ziegler, which is that it does state that although Article 10 and 11 rights aren't trump cards, they are more than a significant consideration. The content of the expression may have greater weight if it's political. However, the court shouldn't descend into approval or disapproval of any particular viewpoints. That may not be the case in practice, but that is something that is reiterated in the Ziegler judgment. Lawful excuse does include the need to consider Articles 10 and 11, because quite surprisingly, the prosecution was suggesting that it doesn't. Further, that the right to pass and repass, that's the right of the general public to pass and repass a highway, doesn't take primacy over Article 10 and 11 rights. And Article 10 and 11 includes deliberately disruptive protests. And also, Owen and Henry have got permission to appeal to the Supreme Court. Those aren't exactly the questions as they have been framed, but essentially it's about whether the High Court's approach to proportionality was correct, in that is a total blockade of a road, will that always justify a legitimate interference with Article 10 and 11 rights? And also, was the test to be applied by the appellate court correct? That's the end of my slot, and thank you very much.
Thank you very much, Shahida. I'm afraid we're running rather short of time. We've rather overrun. I hope Shinna's got enough time to devote to his subject. The reality is that there is a very significant amount of case law in this area, and the issues are not always as straightforward as we would like. But can I then proceed just to introduce Shinna? He's a very welcome new addition to Garden Court Chambers. He joined earlier this year. He's developed a practice in protest law, and he's recently represented environmental and animal rights protesters. And last year, he successfully defended a number of Extinction Rebellion protesters. He's on the committee for the Black Protest Legal Support. He previously worked at the United Nations and a variety of non-profit legal organisations, including Justice. And his talk is going to look at the case law of the European Court of Human Rights on direct action protests. So, Shinna, over to you.
Thank you, Henry. I'm just going to share my screen, everyone, and hopefully the nods of heads will be an indication that you can see it. Moment. Okay. So, in this presentation, we'll be looking at the jurisprudence of the European Court of Human Rights, which lays down a number of important guiding principles which should inform the judicial interpretation of the right to protest in the UK, as just raised by Shahida when talking about Ziegler. Now, I'll be looking at the extent to which direct action is protected as a form of protest in terms of obstruction, boycotts, and counter-protests. Now, firstly, I want to briefly explore with you the general protection offered to cases which cause destruction, protests which cause destruction. A case that I've put here on the slide is a case of Kuznetsov and Russia. And it's really, rather than going into the facts of it, because I'm conscious of the time, I'll just take you to the key point raised in it. And it's that, as a general principle, the court reiterates that any demonstration in a public place inevitably causes a certain level of disruption to ordinary life, including disruption to traffic. And it's important for the public authorities to show a certain degree of tolerance towards peaceful gatherings. Freedom of assembly guaranteed by Article 11 of the Convention is not to be deprived of all its substance. We've also seen that in the case below of Ezelin, that the court considers that the freedom to take part in a peaceful assembly is of such importance that it cannot be restricted in any way, so long as a person concerned does not himself commit any reprehensible act on such occasion. Now, the thing is on that occasion, the court didn't define what exactly it meant by reprehensible acts. So then this takes me to a case which may assist us. If the slide will change, okay. This is the case of Kudrovicus. Now, this case, you may think that the courts have not, the Strasbourg court has not generally been especially sensitive to the nuances between types and forms of motivations for protest. Forgive me, the domestic courts haven't been especially sensitive to that. Now, in this case, it concerned farmers who were convicted of riot following a 48-hour blockade of 3 of the largest highways in the country. They used tractors to block the highways. And this was part of a protest of force of government to make concessions in a political dispute concerning subsidies. Now, the obstruction caused serious and widespread disruption across the country. The Grand Chamber, in this case, noted something that I think is quite key, is that intentional serious disruption by demonstrators to ordinary life and to the activities lawfully carried out by others to a more significant extent than that caused by normal exercise of the right of peaceful assembly in a public place might be considered a reprehensible act within the meaning of the court's case law. We're talking of the case of Ezelin. Such behaviour might therefore justify the penalties even of a criminal nature might. Now, the point here is that are those words, that phrase, intentional serious disruption, can that be considered almost as a threshold test? If the circumstances were, for example, as touched on by Shahida, maybe rather than 3 highways, obstructed 1, or a singular pathway rather than multiple, would that be more of a symbolic form of disruption? And would that be the kind of boundary in which the court could allow such disruption? So it's something that certainly could be used as an indication, as a threshold in that case, because if a protest is obstructive, like I said, in a symbolic way, then rather than so disruptive that it ceases the activity, it could be protected. Now, this takes me on to boycotts. And this is the case of Baldassi and others against France. Now, the activists in this case took part in a protest in a hypermarket calling for the boycott of Israeli products. As they displayed articles and handed out leaflets, they also got customers to sign a petition inviting the supermarket to stop buying Israeli goods. Now, the state argued by calling on the hypermarket customers not to purchase products from Israel, that the activists incited people to discriminate against the producers or suppliers of said country on the basis of geographical origin. The issue for us to consider is, in short, it involved the case addresses the tension between the exercise of freedom of expression and the right of others not to be discriminated against. Is incitement to differential treatment necessarily the same as incitement of discrimination? Had there been a violation of Article 10 by the activists? Now, how did the court resolve this matter? I think this extract was quite useful, is that the court said that the call for a boycott, however, is a special means of exercising freedom of expression, in that it combines the expression of a protest opinion with the incitement to differential treatment, so that depending on the circumstances that characterize it, it is likely to constitute an appeal for discrimination against others. However, the call for discrimination is a call for intolerance, which, together with a call to violence and a call to hatred, is one of the limits not to be exceeded under any circumstances in the exercise of freedom of expression. I think what's key here in this case is that the activists in this case weren't using words of hatred. Their speech went to the extent of commenting on the state's policies and how it approached people within its own jurisdiction. It was political commentary. And to be clear, the applicants weren't convicted of making any racist or anti-Semitic remarks. So the court had repeatedly pointed out that Article 10.2 leaves little room for the restrictions on freedom of expression in the area of political discourse on matters of general interest. Nevertheless, it remains in the public interest unless it degenerates into calls for violence, hatred, or intolerance. There is a limit not to exceed. So there we go. That's the ambit which the court is saying, which under Article 10, the protesters and activists were protected under. There was no dispute by any party that the boycott represented an exercise of freedom of expression. So differential treatment does not amount to discrimination if it's based on objective and reasonable justifications, not unjustified hatred or intolerance. So you may consider that anti-discrimination laws that manifest itself in civil criminal sphere shouldn't be used as a means to silence human rights defenders or censor legitimate criticism of state policies. I'm conscious we're short on time, so I'm going to briefly touch on the next case, the case of Ollinger and Australia. Essentially, what it raises something in which we have Ollinger had an assembly with a small number of others as a memorial to commemorate the Salzburg Jews killed by the SS. Now, it was on a day which was which Comrade 4 were commemorating, as they had done for 40 years, former SS colleagues who died in the war. Now, I think this case is particularly interesting because it kind of gives us a context or relevance as to what was going on in the last couple of weeks between BLM protesters and where it was some described as football hooligans or EDL, right, protesters. I think it points something really key, and this is the point. Because the state in the case of Ollinger tried to ban the protest of Ollinger's assembly, and what the court said, the Strasbourg court said, is that under Article 11, the state is compelled to abstain from interfering with that right. which also extends to a demonstration that may annoy or give offence to persons opposed to the ideas or claims it is seeking to promote. If every probability of tension and heated exchange between opposing groups during a demonstration was to warrant its prohibition, society would be faced with being deprived of the opportunity of hearing different views. On the other hand, states may be required under Article 11 to take positive measures in order to protect a lawful demonstration. And you may have noticed that if you had read some of the news and the press release by the Met as to the conditions that they were going to give protesters to facilitate both the EDL right-wing march and also the BLM march. And that's the kind of thing that we have to be looking at, the proportionality, what's put in place. They can't just outright ban them on the risk or anticipation of violence that may or may not occur between two parties. I'm conscious I've blitzed through that quite fast. Luckily, there's a recording and you can always go through it again. But I think the key takeaways, for example, with that is that it breaks the trend of cases which sanction restrictions on protest because of their opposing sides, like I've said. So in summary, for this, the Strasbourg court will not tolerate the arrest and detention of purely peaceful protesters. That's in the case of physical obstructions, and that's in the case of certain forms of boycott that don't overstep the mark of unjust discrimination. And that's also in the case of protests which counter-protest. So on that note, I want to thank everyone for coming, and I'm going to pass on back to Henry.
Yeah, thank you very much indeed, Sheena, and thank you to all our speakers. I thought they were extremely helpful talks, I thought. We've overrun our time, but there is just one question on the chat in relation to an article which appeared in today's Guardian about proceedings which are being taken by, I think, a journalist or an activist of some sort who was challenged by the police at a demonstration for wearing a T-shirt which was less than polite about our current Prime Minister. And I think that Owen has indicated that he might have some observations about that.
Yeah, I saw the question in the chat. Thank you. This is the case of the police stopping a protester or an activist wearing a T-shirt that said "Fuck Boris" on it, and she seemed to be threatened with arrest under Section 5 of the Public Order Act. I'm not sure she have taken place, but it is quite interesting to look at what took place within the
Owen, I think we may have some difficulty hearing you. Have other people got the same problem? Yeah, I think so, yeah. I'm afraid, Owen, I think that we may have to bring proceedings to a close. Thank you very much to everybody for attending.
Henry.
Oh, you're back.
I'm back, okay.
Yeah,
So,
I'm afraid you phased out. Thanks everybody. There's another webinar next week on continuing in this series. I hope you've all found it useful. Many thanks for attending, and goodbye and God bless. Thank you very much.